Good afternoon. I'm pleased to welcome everyone to the 12th Culliton Lecture in Criminal Law and the start of the College of Law's Speaker Series for the 2011-2012 academic year. The Culliton Lecture, as you know, has a long history as a lecture focused in the area of criminal law, and we're delighted to have with us today Professor Steve Coughlan, a professor at the Schulich School of Law at Dalhousie University. In his position there, he's won awards for his teaching at the faculty, university, and Atlantic region levels. He's the author or co-author of a number of books. His latest book is co-authored with Glenn Luther of our faculty, and it's Detention and Arrest. And I'd mention to everyone as well that if you have time later this afternoon, there's a book launch occurring at the College of Law for that book at 4 p.m., I think in the student lounge, and everyone would be very much welcome to attend that as well. Professor Coughlan, along with Tim Quigley from our faculty, is a co-editor of the Criminal Reports and of the National Judicial Institute's Criminal Law Essentials e-letter, and he has a long series of publications, a great deal of experience in the criminal law area, but his particular topic today is criminal justice in a post-rule of law world, and I'll let him explain that. So without any further ado, welcome Professor Steve Coughlan for the Culliton Lecture.
Thank you very much, Dwight, for the introduction. And may I say I am very honored and pleased to have been invited here to the University of Saskatchewan to deliver the Culliton Lecture. I probably should say, actually, that of course my immediate reaction on being invited was to be honored, especially to come to a faculty that is as strong in criminal law as the University of Saskatchewan is, of course, with Tim Quigley and Glenn Luther and Lucinda Vandervoort and Michael Plaxton, and of course your new dean, Sanjeev Anand. And it was actually as I was running that over in my mind that the honors sort of changed a little bit to intimidation and nervousness. Because of course typically I'm talking about criminal law to first-year law students. And if I say things that are ridiculous, it's years before they discover that, and I'm not actually accountable anymore. I'm not even there in front of them. Whereas here I'm having to speak to an informed group of people about the subject, and so of course that does tend to make one a little bit nervous. I have to say I'm also honored to be delivering a lecture named after your former Chief Justice Culliton, who of course served the province on the Court of Appeal for 30 years, almost 20 of those years as the Chief Justice of the province. Served in your legislature, left the cabinet in order to serve in the armed forces during the Second World War. It seems to me that someone who chose to serve the province in so many ways, particularly both on the bench and in the legislature, must likely have been someone with an interest in the rule of law. That's not the reason that I chose the topic, but I think it is a happy coincidence that it is an appropriate topic for the occasion. So what is the rule of law? I mean, if we're going to talk about what it means to say we're in a post-rule of law world, we'd better know what a rule of law world would look like. And the rule of law, seemingly, is very important to us. I mean, the preamble to the Charter itself talks about the fact that we're founded on principles which respect the supremacy of God and the rule of law. So that's like pretty good company to keep, especially when you consider that it was God that was controversial in terms of putting on the list. You know, rule of law, everybody was behind having that there. And when courts consciously think about the rule of law, when they're talking about it, they always say the right things. In the Ontario Court of Appeal, for example, recently in the Abdullah Khader extradition case, refusing to extradite him because of the misbehavior, really, of the United States towards him. They commented, "The rule of law must prevail even in the face of the dreadful threat of terrorism. We must adhere to our democratic and legal values, even if that adherence serves in the short term to benefit those who oppose and seek to destroy those values. For if we do not, in the longer term, the enemies of democracy and the rule of law will have succeeded. Similarly, the Supreme Court of Canada, in a relatively recent decision, in Ferguson, the particular topic was constitutional exemptions, but again, they're dealing with the issue of the rule of law. And they say that the divergence between the law on the books and the law as applied, and the uncertainty and unpredictability that result, exacts a price paid in the coin of injustice. It impairs the right of citizens to know what the law is in advance and govern their conduct accordingly, a fundamental tenet of the rule of law. So, when courts are consciously thinking about the rule of law, they always say the right thing. The argument that I want to pursue here today is that when they're not consciously thinking about it, courts don't always do the right thing. Really, what I'm talking about more than anything else is simply an attitude of mind among judges and among other participants in the criminal justice system, prosecutors, police, and defense counsel, for that matter. This is an unpromising start to a talk, but I will say that because it's about an attitude of mind, it is an inherently unprovable thesis that I'm about to present to you. But I think that it might sound plausible. And I should be clear here. I'm not simply saying this is a slippery slope. You know, we have to be careful about where we're headed to. I'm saying we're there. It could be worse, but it's bad enough now. So let's be more specific. What is the rule of law? Formally, the Supreme Court of Canada has recently said in BC Attorney General versus Christie, the rule of law embraces at least three principles. The first principle is that the law is supreme over officials of the government as well as private individuals, and thereby preclusive of the influence of arbitrary power. So that's one, supreme over the government. The second principle requires the creation and maintenance of an actual order of positive laws, which preserves and embodies the more general principle of normative order. And then finally, the third principle requires that the relationship between the state and the individual be regulated by law. More broadly, though, what I think is important about the rule of law is the way in which it is distinguished from something which really is only describable by a term which is no longer politically correct. And it's a term that I don't think we hear a lot, but which used to be tossed around, which is palm tree justice. The notion of the rule of law is that one body creates the rules. A different body decides whether those rules have been obeyed or not, and holds everyone to account to those rules. The government, individuals, everyone is held account to those rules. But the key point for me is that those people who are deciding whether the rules are followed are not the people who decided what the rules were. They're simply deciding whether the rules were followed. We separate those functions. It's in that sense that I think the rule of law is under serious attack. Not, of course, that anyone ever says, oh, we're against the rule of law. Right? You cannot find a court decision where someone is saying we shouldn't have rule of law. This is one of those situations where naming matters. It seems to me it's like judicial activism. Right? If you don't like the decision a judge made, then it was judicial activism. If you did like it, it was judicial independence. We just pick the term that describes the thing we like about it, and the term that you use says where you stand. So nobody says, let's not have the rule of law. What they do is speak dismissively of people who are obsessed with pre-formulated bright-line rules. They decry rigid pigeonholing. They call for a functional approach or a fact-specific inquiry, or develop rules in the factual context of the case, or settle it on a case-by-case basis. Nobody says, let's not have the rule of law, but they do things which amount to not having the rule of law. Now, I should be clear here that I'm not saying rules can't involve the exercise of discretion. Of course, rules can involve the exercise of discretion. The law can and should incorporate discretion in many places. It's inevitable and desirable. My real point is that carried too far, it ceases to be rules which incorporate discretion and becomes discretion instead of rules. I want to pursue in 3 different areas the suggestion that we've crossed that line, that we've entered into the realm of discretion instead of rules. And these are in the areas of criminal procedure, substantive criminal law, and the law of evidence. In particular, within the realm of criminal procedure, I'm going to talk about common law investigative powers. In the realm of substantive criminal law, I want to talk about the approach to statutory interpretation in charter cases. And in the case of the rule of evidence, I want to talk about the principled approach, the principled exception to the hearsay rule. I don't think these are the only examples that one could use, but I think that they are demonstrative of the attitude that I want to point out. The lecturer in me wants to say, I hope this will be evocative for you, and you will think of other areas in which the same thing is happening. The trouble is that the person in me worried about constitutionalism desperately hopes that you won't find any other areas in which that's true, because, of course, it would be a bad thing if it's true even more broadly than I'm suggesting. I am going to try and cover all of those topics. One of the things, however, that I have learned over the course of the years that I've been teaching is that I'm very bad at estimating time. And so I am hoping to stick to the time limits that I've been given here, and therefore if I get towards the end and I don't have time to talk about hearsay, then I'm not going to talk about hearsay. We'll toss those out. I am aware, I think, of the fact that one of those sentences one rarely hears is, "That would have been a good talk if only it had gone on longer." And I know I've often attended these kinds of things and thought to myself, that speaker just passed up a really good opportunity to stop talking. So I will try to be conscious of that in myself here as I talk. So, time to get to specifics and talk about criminal procedure and common law investigative powers. And let me say that I have the most to say about this, and I think that the argument is strongest in this area as opposed to the substantive criminal law and the evidence arguments that I'm going to make. So realistically, if you were unpersuaded when I finish talking about this, you probably could slip quietly out a back door without really missing anything that would have been of interest to you. So, common law police powers. Police powers are, for the most part, defined in the criminal code, and there are a lot of them in there. But the courts have decided that that's not where they all are. And therefore, we have common law police powers as well. And immediately here, I want to draw a distinction between 2 types of common law police powers. On the one hand, we sometimes talk about common law police powers in the sense that the Supreme Court meant in a decision called Cloutier and Langlois, talking about search incident to arrest. And in that case, what they did was look at British cases from the early 1800s, American cases from the mid-1800s, Canadian cases from the late 1800s, and decided, yes, historically, police have always had the power to search a person who they've arrested. Therefore, there is a common law power to search incident to arrest. I'm not terribly worried about that kind of common law power, where we're simply looking at something that actually has always been reflected in the criminal law, just didn't get written down in statute. Rather, my concern is something that is referred to as the ancillary powers doctrine sometimes. The notion that we can create new common law powers that didn't previously exist. And my concerns about the ancillary powers doctrine and common law police powers on that basis really are 2. The first, which is fairly obvious, is that they impair the knowability and predictability of the law. It's difficult to know what the rules are if the rules are being created after the fact. The second point, however, is a little more subtle, I think, or perhaps I just overestimate my ability to understand points. But I suggest as well that the effect of the ancillary powers doctrine in the long run is to undermine that key point about the rule of law, that there is an actual order of positive laws. Particularly the way that the Supreme Court of Canada has approached the issue, we're really departing from that assumption. So, common law police powers in Canada in any serious way, the discussion of them has to begin in 1985 with a decision called Dedman, which has to do with random vehicle stops, and the details don't matter to us, other than the fact that the Supreme Court of Canada was trying to decide, well, did the police have the power to randomly stop these vehicles or not? There was no statutory power under any of federal or provincial legislation, but what the Supreme Court decided at the time was that this was authorized under the common law. There was a common law power to conduct random vehicle stops. They reached that conclusion by applying a British case called Waterfilled, and therefore it's come to be called the Waterfilled Test. Now, many people have pointed out, actually, that this application of the use of the Waterfilled Test turned on its head the goal of the Court of Appeal in England in deciding Waterfilled. It was actually doing exactly the opposite of what Waterfilled was meant to do. And I think I could demonstrate that point by closely reviewing the facts of Waterfilled and facts of some Canadian cases like Stenning and Knowlton and so on. And it's possible that a few of you afterwards would be saying, that was a really sophisticated analysis, but I suspect that the majority of you afterwards would say, I thought it had been going reasonably well up until that point. So I'm going to suggest that we simply take that battle as lost, and whether it's right or wrong, it's clear in Canada, courts can create new common law police powers through the use of Waterfilled. Now, of course that could be dangerous, this notion that you can just create new common law police powers. But, as a matter of fact, after Dedman, it took another 14 years before the Supreme Court of Canada did it again. Dedman was 1985. Supreme Court of Canada didn't actually create another new common law police power until 1999 with a decision called Godoy. In Godoy, the police got a 911 call which was disconnected. So they knew the location, but they didn't know the problem. So they went to the address, and Mr. Godoy met them at the door and opened the door a crack, said, nope, nothing's wrong, you can go away, and tried to shut the door. They didn't accept that as an answer, and they actually forced their way in. He was, as a result, because he resisted, charged with assaulting an officer in the execution of duty. And in fact, when the police went in, they did find Mr. Godoy's partner, who was on the bed and sobbing, and said that he had hit her. And so he was charged both with assault and with assaulting a peace officer in the execution of duty. Interestingly, by the time he went to trial, or when he went to trial, he was acquitted on the charge with regard to his partner, because she recanted. She said, no, he didn't actually hit me at all. I was lying about that. And so we, I think, can have doubt about her recantation, but the trial judge found reasonable doubt. The trial judge nonetheless found him guilty of assaulting the officer. And the key issue in the case, of course, is whether the police were entitled to enter his apartment or not. Because the charge was assaulting an officer in the execution of duty. He was trying to prevent them entering. If they didn't have the right to enter, they weren't in the execution of duty, and he wouldn't be guilty. The court decided that there is a common law police power to enter premises to investigate the cause of a disconnected 911 call. Therefore, the police were acting in the execution of their duty. Therefore, Mr. Godoy was guilty. Now, on the facts of the case, it's hard to summon up a whole lot of sympathy personally for Vincent Godoy, who we're all pretty sure actually did assault his spouse and then applied enough pressure to her that she recanted in court. But at the same time, I think it is worth stopping to think. When he answered the door, when they said, we're coming in to check that out, if he'd said to them, by what authority do you do that? Do you have a warrant? No, we don't have a warrant. Can you point me to some provision in the criminal code that says you have the authority to enter? No, we can't point you to some authority in the criminal code that says we have the power to enter. Can you point to anything that says you have the power to enter my apartment right now? Police would have to acknowledge that no, they did not. So, at least as far as Mr. Godoy is concerned, that's really a retroactive law. there's no way that he could have known that he had to let them in, because none of us knew that he had to let them in until years later, when the Supreme Court of Canada said they had the authority to enter. That's a bit of a problem, having laws which are retroactive. The real problem, I suggest, however, is on the attitude of mind point I want to make, that Godoy was the tipping point. It had been 15 years between Dedman and Godoy. But Godoy somehow put the notion of ancillary powers at the top of everybody's mind, where once it had been a safety valve, which we might occasionally use, it was now on the table from the start. It was the starting point of reasoning. And so in Mann in 2004, the Supreme Court of Canada creates 2 new powers using the Waterfilled Test. In Clayton in 2007, creates a new power. In Kang Brown in 2008, probably creates a new power. It's so hard to understand what they say in Kang Brown. In Gombach in 2010, part of the reasoning is whether there's a new power under the Waterfilled Test. In Sinclair in 2010, it's among the reasoning of some of the judges. Again, suddenly the starting point for reasoning is this trump card. Oh, well, we can always solve the problem of police powers through the use of Waterfilled. If you simply do a quick law search to see how often Waterfilled is discussed before 1999 and after 1999, dramatic increase. So suddenly we have, as I say, really a change in attitude, that we're not as worried about what the law says, we're worried more about what we can make the law say. We can create these powers after the fact. That's just fine, because it's going to get the right result in this case. That, it seems to me, is hard to reconcile with one of those things that the court has said when they're consciously thinking about the rule of law. Again, in Ferguson, it is fundamental to the rule of law that the law must be accessible and, so far as possible, intelligible, clear, and predictable. Well, of course, that's exactly what common law police powers are not. They are created after the fact, and it is not possible for the people who were involved at the time to know what they are. That was the first of my concerns, simply is that it reduces the amount of predictability and knowability. But actually there is more than that. As I said, I have a second concern, which is the way in which it is a challenge to the order of positive laws. And that's because the way in which courts, the Supreme Court of Canada in particular, has begun to do the Waterfilled Test has changed. In Dedman, they set out fairly explicit criteria for when a random vehicle stop could take place. In Godoy, they set out fairly specific criteria for when the police could enter premises. In Mann, they set out a 3-part test for when there can be an investigative detention. They set out a further 3-part test for when there can be a search associated with an investigative detention. At least we can say of those common law powers that after the fact they are relatively statute-like. We know the specific criteria that have to be met. There's, of course, room for slippage, but there's room for slippage everywhere. But that's not what the Supreme Court did with its decision after Mann, which is Clayton. In Clayton, the police received a tip. Police in Toronto received a tip that a bunch of black guys who were hanging around 4 particular types of cars had guns like Glocks, the tipster said, and they were in the back parking lot of the $1 Million Saloon, a strip club. And so within minutes, the police arrived to block all the exits to the parking lot with the plan to search everybody who left. And the actual dispute in the case doesn't matter much to us. I mean, the actual dispute in the case was really over whether it was reasonable to search everybody who left or whether they should only be searching the 4 cars that they had specific descriptions for. The real point, however, to recognize for my purposes here is their use of the Waterfilled Test. Justice Binney, in dissent, did the same kind of thing that had been done in Dedman and had been done in Godoy and had been done in Mann. He thought to himself, well, we have to see whether there is a police power. And this is actually consistent with what the Supreme Court had said in Mann. And I think of this as a very important quote in judging the relationship between the individual and the state. In Mann, Supreme Court said, absent a law to the contrary, individuals are free to do as they please. By contrast, the police, and more broadly the state, may act only to the extent that they are empowered to do so by law. I actually think of that as extremely important. That seems to me to be a foundational notion to a liberal democratic society, that individuals can do things unless the state says you can't, but police can only do the things we specifically say the police are allowed to do. That's the notion of democratic freedom. Justice Binney, in dissent in accordance with that, tries to decide, well, so did the police have the power to set up this blockade to stop people leaving the parking lot? And he looks at Dedman, which is random vehicle stops, and he thinks, no, it's not a random vehicle stop, so it's not Dedman. He looks at Mann, and he thinks, well, no, because they don't know if they're stopping everybody, not particularly people, so it's not Mann. He looks at a Quebec Court of Appeal case called Murray, which had to do with setting up roadblocks. Says, no, it's not the power in Murray. So there is no existing common law power that would authorize the police. And he calls for the creation of a new common law power, and he sets out 5 criteria that would have to be met for the police to have this new power. So that, at least, I suggest, is consistent with the way in which other courts had approached common law police powers. It's not what the majority does, however. The majority decision, written by Justice Abella, I guess all I can do is tell you, really, this is it. This is, I promise you, there's nothing more than this. They say, in the totality of the circumstances, the initial detention in this case was reasonably necessary to respond to the seriousness of the offense and the threat to the police's and public safety inherent in the presence of prohibited weapons in a public place, and was temporally, geographically, and logistically responsive to the circumstances known by the police when it was set up. The initial stop was consequently a justifiable use of police powers associated with the police duty to investigate the offenses, and did not represent an arbitrary detention, contrary to Section 9. Their reasoning really doesn't amount to anything more than it was reasonable to do this, therefore it didn't violate the Charter. There's no new power, no new criteria, no test that can be applied in later cases. Simply, this was reasonably necessary and responsive to the circumstances, therefore it's okay. Therefore, it didn't violate the Charter. That's very different. That's not a power at all. It collapses the discussion of power and the Charter discussion into one single thing. Why was there no Charter violation? Because they were authorized. Why were they authorized? Because we said they were authorized. Why did you say they were authorized? So there wouldn't be a Charter violation. I mean, it's completely circular. I want to contrast it, ironically, to a pre-Charter case. The pre-Charter case of the Supreme Court of Canada in R versus Collette. Collette was someone who was thought to be dangerous and had weapons. And so the police had obtained a warrant under the Criminal Code to seize his weapons. The trouble is the Criminal Code provision, that's all it said. It said you can get a warrant to seize. It didn't say you can get a warrant to search. Most provisions in the Criminal Code include authorizing both search and seize. This one only authorized seizure. And so the police went onto his premises and took the weapons. And he objected that they were not authorized to do that. They were authorized to seize, but they weren't authorized to search. And the Supreme Court of Canada said, you're absolutely right. That was obviously a mistake. The Criminal Code clearly was badly drafted. The police ought to have the power to search, but they don't. Therefore, Mr. Collette's in the right. And as I say, it's pre-Charter. It's now no longer possible to reason in that way. We've lost the ability for the courts to say, police should have this power, but they don't. The reasoning in Clayton means that if the police should have the power, then they do. That's it. Should have the power is the only question we ask anymore. If they should, they do. which means we are no longer creating an order of positive laws. We are no longer creating powers. We are judging after the fact whether the police behavior was reasonable. If it was reasonable, it was okay. But that's palm tree justice, not positive set of positive laws. That's objectionable in principle, of course, but I do want to point to the fact that it's actually quite difficult in practice as well, from everyone's point of view. Let's conduct a thought experiment here. Imagine, as we sit here, right now, this moment, police come in these two doors. They say, everyone sit still, please. This won't take long, probably only about a half an hour or so. We want to go through everybody's bag. Are they allowed to do that? I don't know. Tim Quigley wrote the book on criminal procedure. Literally wrote the book. I promise you, Tim doesn't know. We could try saying to them, well, why do you want to search everybody's bags? And maybe they'd say, well, because we got a tip that there's a gun. Okay, well, gun, that's more likely than drugs, because if it was drugs, probably not. If it's a gun, maybe. We could say to them, okay, but how long ago did you get the tip? Okay, it's unlikely they're going to answer that. But maybe they're going to tell us the tip came only 5 minutes ago. Okay, how reliable is the tipster? Have you corroborated any of the information that the tipster gave you? How many exits are there from this building? Is it possible that the people who you're looking for have already left, or are they definitely still in this room? Even if the police who were searching knew the answers to those questions and provided us with the answers to those questions, we still would not know whether the police had the authority to search. More to the point, they don't know. The police no longer know what their own powers are. We tell them to act in a way that is reasonably responsive and necessary in the circumstances. I want to suggest that the simple way to put that is guess. I don't mean this as a rhetorical device. I mean, quite literally, it is impossible for citizens and police to know what powers police have in citizen-police interactions. That, I suggest, is an undesirable state of affairs. The last word from the Supreme Court of Canada on this was in Kang Brown in 2008, where 4 of the 9 judges actually addressed this point. They were being asked in Kang Brown to create a new common law police power. And 4 of the 9 judges, interestingly, Justice Abella, who had written the majority decision in Clayton, among them, said, I'm paraphrasing, hold on there, guys. They suggested, no, wait, we're going too far. This can't be our go-to option. You can't always ask us just to create a new common law police power. It is not our proper role. That's something we have to leave to Parliament, not the proper role of the courts. Only one judge actually answered them. The other 4 of the remaining 5 simply went ahead and created common law police powers. They didn't even bother answering that we shouldn't. It was only one judge, Justice Binney, interestingly, the one who dissented in Clayton, who replied to this. And I think this is one of the most ironic statements I have ever seen in a Supreme Court of Canada judgment. Justice Binney says, in fairness to litigants, the court ought not, in my respectful view, to waver unpredictably between the willingness of the court to explore adjustments in the common law of detention or search and seizure and the hands-off or leave-it-to-Parliament attitude my colleagues advance in this case. How are litigants to anticipate whether they will find the court in a can-do mode or a leave-it-to-Parliament mode? We have crossed the Rubicon. So, in the interests of certainty, he says, we have to be constantly willing to make new rules after the fact. All right, well, time rushes on here. I want to talk a little bit, because I am aware that I'm moving through time here at a faster rate than I had anticipated. I want to talk a little bit, at least about substantive criminal law, and we'll see whether I can get to the principled exception to the hearsay rule. In substantive criminal law, it seems to me that there is a real concern in the way in which the court approaches charter claims, and I want to suggest avoids charter claims. Let me quickly do a contrast between two decisions, a relatively early one, 1994 decision in Haywood, and a more recent one, the 2004 decision in Canadian Foundation for Youth, Family and the Law, commonly known as the Spanking case. In Haywood, the issue was whether a particular provision in the criminal code was overbroad, whether it did more than it should. And what it did was say that people who had been convicted of sexual offenses were not allowed to loiter in public parks or a whole long list of places. And it was clear the purpose of the law was to prevent pedophiles from being near children. The difficulty was that lots of these public places were not places where children would be, and the sexual offenses were not necessarily ones with regard to children. And so the argument was, to protect children, you don't actually need to say that somebody can't go backwoods camping 100 miles from any child. The dissenting judges in Haywood said, hey, you know what? We could solve this whole problem if we took the word loiter to mean hang around with malevolent intent towards children. If the word loiter meant hang around with malevolent intent towards children, then this law would not be overbroad. It would only apply in circumstances where we would actually have a genuine concern about children. The majority judges said, well, yeah, maybe, but that's not what loiter means. Loiter means hang around without a purpose. So maybe loiter meaning that would solve the problem, but that's really not important because it isn't what loiter means. And so they found that the law violated the charter, and they struck it down, and Parliament created a new law which was more limited. Let's contrast that to the Spanking case. Section 43 of the Criminal Code says that parents and school teachers and people who are acting in loco parentis can apply force to children by way of correction as long as it was reasonably necessary in the circumstances, or reasonable in the circumstances. And that law was challenged as vague and overbroad. The majority of the court found that it was neither vague nor overbroad, but what I want to suggest is that we've had a shift in attitude, and really the majority in the Spanking case do exactly the kind of thing that the majority in Haywood refused to do. The majority in Haywood say, no, reasonable, this statute is not vague and it's not overbroad, because the word reasonable obviously means not to children under 2, not to children over 12. You can't use objects. You can't hit them in the head. The gravity of the precipitating event is irrelevant, and teachers can't actually use it except to remove troublesome students from the classroom. And since it's obvious that that's what the word reasonable means, this law is neither vague nor overbroad. I have to say, by the way, that I don't have the same knowability concerns about this as I do about others. And I want to tell you a very brief story here, because very shortly after this decision came down, my son turned 13. And apparently they teach them this decisions in the schools, because we were in our backyard and he made some smart aleck remark, and so I swatted him across the back of the head. And he said, hey, you can't do that, I'm 13. And I said, no, I'm not allowed to apply force to you by way of correction. I'm not expecting you to learn anything from that. I was just hitting you. In any event, in the Spanking case, Justice Arbour, in dissent, I thought put matters very well in her objection to the approach that the majority had taken. Absent a finding of constitutional violation by a Parliament, the reading down of a statutory defense, as is done by the Chief Justice, amounts to, in my respectful opinion, an abandonment by the courts of their proper role in the criminal process. I would say you couldn't put it better, but actually Lewis Carroll put it better. When I use a word, Humpty Dumpty said in rather a scornful tone, it means just what I choose it to mean, neither more nor less. And it seems to me that in cases like the Spanking case, it's one of these numbered company names, but a subsequent decision of the Supreme Court of Canada, Montreal versus, I think it's 2952-1366 Quebec Incorporated, one of those really memorable names. They've done the same kind of thing there. I mean, it was a noise bylaw. And the majority decided that Justice Binney said noise, that means noise. You know, stuff you can hear outside. That's what the statute said. The majority said, no, noise means that it's got to be a disruptive noise, it's got to be associated with a building, it's got to be detectable as separate from the environmental noise, and it has to adversely affect people's enjoyment. Justice Binney says that, you know, that's just not what noise means, and that they should be passing judgment on the statute as it was passed. Now, I do have to say, I have some sympathy for courts when they engage in this kind of interpretation. Because in some ways, you can think, okay, well, we end up in the same place. We can either say there's a charter violation and read it down to mean this, or we can just start by reading it down to mean this and then say there's no charter violation. Either way, we end up in the same place. And let's acknowledge, courts face ill-informed criticism when they use the charter. It's understandable that courts might want to avoid that ill-informed criticism, and this kind of creative interpretation is a way that they can do that. I think that imposes an obligation on us to defend courts in the media when they are upholding charter rights, because of course they can't write letters to the editor or enter into the fray themselves. But even if it's understandable, it's undesirable. The message it sends to the players is everything is on the table. It really doesn't actually matter what the statute says. What matters is what the statute should say. So you are free to show up in front of us and argue what the law should be, instead of arguing what the law is. And again, that's not an order of positive laws. That's going and asking the judges to decide the law, to create the law. Reasonably, in the minds of the Crown, any interpretation is worth trying.